Hello and a very warm welcome to World This Week by Latest Laws. This is our weekly program, so subscribe and press the bell icon to get notified. My name is Monica Rahar and let's get started by having a look at Supreme Court this week. The Honorable Supreme Court on Monday expressed shock and displeasure on being told that over 1,000 cases had been filed under the Section 66A of the IT Act. This section was scrapped back in the year 2015 by the Honorable Apex Court itself in the case of Shreya Singhal versus Union of India. This section, it allowed police to arrest people for posting offensive content online. On Tuesday, the Apex Court directed the central government to ensure that all people in mental health homes they receive COVID-19 vaccination at the earliest. The Supreme Court also took serious note of the Maharashtra government's shifting of mentally ill patients to beggar homes. On Tuesday, the Apex Court refused to permit Rath Yatra across Odisha except at Puri Jagannath temple. The government of Odisha had earlier permitted Rath Yatra only at Puri, while it allowed rituals within temple complexes of all other Jagannath temples. This petition was filed in the top court against the Odisha High Court order, which dismissed a batch of pleas challenging this order of the state government, which restricted the carrying out of the Rath Yatra in temples due to the outbreak of COVID-19 virus. This plea stated that a total ban on the rituals, it will be an action against their right to religion and their fundamental freedom to have an expression of their religious beliefs. Observing that use of toolkit for political propaganda cannot be banned in a democratic country like India, the Supreme Court on Monday refused to entertain a PIL which sought probe against Congress and also its deregistration for allegedly creating a toolkit to harm the image and reputation of Prime Minister Narendra Modi on handling the COVID-19 crisis. The court, in a judgment which is titled as Sheikh Ahmed versus the State of Telangana, held that merely proving the kidnapping of a person is not sufficient for a conviction for the offence of kidnapping for ransom under Section 364A of the Indian Penal Code. It must also be proved that there was a threat to cause death or harm to the kidnapped person, or that the kidnapper by his conduct gave rise to a reasonable apprehension that such person may be put either to harm or death. On Wednesday, the Apex Court directed the centre and the state governments to file the latest compliance report within a period of 4 weeks regarding the timely and the transparent appointment of information commissioners in the Central Information Commission under the Right to Information Act of 2005. The Union of India and all other state governments are directed to file the latest compliance report within a period of 4 weeks from today. Petitioner is also permitted to file an additional affidavit, the bench said. On Thursday, the Supreme Court said that it will hear on July 20 the Amazon plea against the Delhi High Court verdict, which stayed the directive of its single judge and also paved the way for the multi-billion-dollar deal to amalgamate Future Retail Limited with Reliance Retail. A three-judge bench of Justice R.F. Naraman, Justice K.M. Joseph and Justice B.R. Gavai was informed by senior advocate Harish Salve appearing for the Future Group that a Singapore tribunal will commence hearing on the issue from July 12 and thus requested the proceedings on appeals be adjourned for a week. On Friday, the Apex Court in its order decided to drop the initiation of contempt of court proceedings against the real estate company Supertech after it refunded the amount to many home buyers in one of its housing projects in Noida. The top court had earlier asked the real estate company to refund the money to its deserving home buyers. Now let's proceed to the next segment of our news analysis and have a look at the Delhi High Court this week. So on Friday, the Honorable High Court of Delhi issued notice to the following entities starting with the Ministry of Environment, Forest and Climate Change, Ministry of Coal, Governments of UP and Delhi, the Central Pollution Control Board and others on a plea alleging fly ash disposal causing air, water and soil contamination due to the use of red bricks in the construction projects being carried out by both public and private entities instead of using fly ash brick, which is in violation of the law which is governing this particular subject matter, both in terms of the Supreme Court and the High Court precedents and also notifications of the government. On Friday, the Delhi High Court was informed or told by WhatsApp that it has voluntarily put its updated privacy policy on hold and that users in India will not be affected. This was said during a hearing in the Delhi High Court about WhatsApp and Facebook's plea challenging an inquiry which was initiated by the Competition Commission of India into the updated privacy policy of WhatsApp. On Wednesday, news agency Press Trust of India, it challenged the centre's information technology guidelines for intermediaries and digital media ethics code rules of 2021 in the Delhi High Court. The PTI argued before the court that the rules would usher in an era of surveillance and fear, thereby resulting in self-censorship, which results in abridgment or also violation of fundamental rights as enshrined in Part 3 of the Constitution of India. On Thursday, the Delhi High Court sought response of the Delhi government in response to a plea which sought distribution and complete utilization of all food grains and items of dry ration kits which are laying at different places in Delhi and which were purchased under the Mukhyamantri Corona Sahayak Yojana to the needy and eligible people. A division bench of Chief Justice D.N. Patel and Justice Jyoti Singh issued notice to the Delhi government and others and listed the matter for hearing on August 23. Now in the next segment, let's proceed with the Bombay High Court. So on Thursday, the Bombay High Court asked the Maharashtra government to produce any additional documents or records to show that a Pune Sessions Court judge who granted an extension of time to the police to file its charge sheet against lawyer Sudha Bhardwaj had the jurisdiction to do so. Sudha Bhardwaj, we need to understand, is an accused in the 2018 Algar Parishad case. She filed a petition before the Bombay High Court seeking default bail on the ground that the Pune Session Court judge, he was not a designated special judge under the National Investigation Act as was necessary, since the Special Anti-Terror Law, which is the Unlawful Activities Prevention Act, was invoked against her. On Thursday, the Bombay High Court said that endeavour of schools across Maharashtra in the present COVID crisis, it should be to amicably settle fee-related disputes with the parents instead of debarring students from attending online classes and turning this whole issue into a legal battle. On Wednesday, the High Court issued notice to the central and the Maharashtra government, among others, in response to a PIL alleging that Truecaller mobile app, it shared user data, thus breaching their privacy. Now, this particular PIL, it also further alleged that the Truecaller app collects data of all users. It shares such data with some of its partners without the user consent and dumps the liability on the users. Now, let's proceed and have a look at an update coming from the Uttarakhand High Court. On Thursday, the Uttarakhand High Court has extended the stay on the Char Dham Yatra till 28th of July. The High Court earlier on 28th of June had stayed the State Cabinet's decision permitting the Char Dham Yatra with a limited number of pilgrims and also ordered live streaming of the Char Dham shrines. In view of the COVID-19 crisis and the poor health preparedness, the decision of the government has been put on hold by the High Court. Meanwhile, the Uttarakhand government on Tuesday filed a special leave petition before the Supreme Court against the Uttarakhand High Court's order staying the Char Dham Yatra. Now let's proceed and have a look at the Kerala High Court. The Kerala High Court restrained the central government from taking any coercive action against the News Broadcasters Association under the new IT rules. The court passed this interim order on the NBA's plea challenging the new IT rules on the ground that they give government authorities excessive powers to unreasonably restrict the freedom of speech and expression of the media. The bench of Justice P.B. Suresh Kumar stated, and I quote, "The respondents shall not take any coercive action against the petitioners for non-compliance of the provisions contained in the rules," unquote. Now moving on to the next segment, which is of Madras High Court. So the central government has informed the Madras High Court that the Justice A.K. Rajan committee, which is constituted by the Tamil Nadu government to look into the impact of NEET exam on students from socially backward classes, it is neither requisite nor valid. The submissions have been made in a PIL which is moved by the BJP State Secretary seeking the quashing of an order issued by the Tamil Nadu government on June 10, constituting this committee headed by Justice A.K. Rajan to study the impact of NEET exam on such students. On Tuesday, the Madras High Court directed the state government and the University Grants Commission, which is UGC, to explain the various shortcomings in providing online education to higher education students. Now let's proceed with the miscellaneous segment of our news analysis. Kiran Rijiju has been appointed as the new Law Minister of India. The office of Law Minister was vacated after the resignation which was given by the former Law Minister Ravi Shankar Prasad. Kiran Rijiju is an Indian lawyer and politician from the state of Arunachal Pradesh. A member of the BJP, he is the former Minister of State of the Ministry of Youth Affairs and Sports and also the Minister of Affairs in the Ministry of Minority Affairs of India. Mr. Justice A.K. Mishra, the chairperson of National Human Rights Commission, while expressing serious concerns over the continuation of manual scavenging, has stated that the widespread persistence of this practice, despite having laws and guidelines for its elimination, it not only goes against the values of our constitution, but it also violates numerous national and international rights which are enumerated in various national and international instruments which are legal. On Wednesday, the Kerala government challenged the High Court's order quashing 2 FIRs which were filed against Enforcement Directorate officials in connection with the gold smuggling case. The special investigation team, which was constituted to investigate sacrilege cases, has on Friday filed the first challan in a case of desecration of Shri Guru Granth Sahib before the Court of Judicial Magistrate First Class, Faridkot. So the SIT head has said in this matter that the challan has been presented against 6 accused who were arrested in this case. Now the next date of hearing is fixed on 20th of July. After the Supreme Court order, the Chandigarh administration has written to the Ministry of Power for further course of action on the privatization of the electricity department. We need to understand here that on 28th of June, the Supreme Court had stayed the order of the Punjab and Haryana High Court, whereby the privatization process was put on hold. The Ministry of Power has appointed a consultant to help with the process to privatize the electricity department. Keeping in view the current COVID situation and the decrease in number of cases in Delhi, the Supreme Court Bar Association has once again written a letter to the Chief Justice of India, N.V. Ramana, and requested him to start the physical functioning of Supreme Court following strict compliance with the COVID protocols and also appropriate behavior. Now let's proceed with the last segment of our news analysis, which is the international news. Now let's proceed to the international segment of our news analysis and have a look at the world this week. A civil rights group has filed a suit against the New York Correction Department for not turning over records on how it uses facial recognition technology on visitors at the state lockups. The New York Civil Liberties Union, it states in this matter that it requested records from the Department of Correction and Community Supervision on September 23, stating that the public has the right to know basic facts about how the notoriously inaccurate and prone to error technology is being used at lockups. On Friday, a Supreme Court judge in Brazil opened a criminal investigation into President Jair Bolsonaro's response to allegations of potential corruption in a health ministry contract to buy 20 million doses of COVID-19 vaccination, which is developed by India's Bharat Biotech. That's all we have for this week. The links of all these news updates, they are made available for your kind consideration in the description section. You may refer to them. Thank you for being with us.